ladies and gentlemen. This is the continuation of the meeting of the Board of Adjustment today, July 9, 2015. I should note that there has been a change in board members who are going to be considering the appeal we are dealing with here in a few minutes. And that will become apparent very quickly as our trustee clerk calls the roll.
Baird Goodchild.
Here.
John Haxby.
Here.
Robert Stewart.
Here.
Also present is Courtney Kitchen, Board Counsel, and Lisa Slusner, Board Support. We have a quorum.
Thank you. We are here on BOA Appeal number 2015-1, and that arises out of the Planning and Zoning Commission Resolution 2015-001, commonly referred to as the South Anchorage High School Stadium Improvements case. The first thing is that we need to talk about any disclosures regarding potential conflicts of interest. Mr. Haxby, do you have anything? Okay, Mr. Stewart. Okay, and I, for myself, I need to state that I know Alex Slivka slightly, and that is from membership in the Rotary Club. Mr. Slivka is a member of the Downtown Rotary Club, which I visit quite frequently, and I have gotten to know him tangentially there because he was the president for a year. But this does not rise to the level of a conflict. It is simply that I want to disclose for the record that I have met Mr. Slivka and know him slightly. All right, we will then come to the consideration of that case all by itself. The threshold issue, and that of course, depending on how we view this, may very well put an end to our further consideration of the case right away, is that issue number one presents itself in this fashion. Is the proposed sports facility subject to the site selection process of AMC 2103-140? And in order to bring this to start discussing this issue, I will entertain a motion that it is not subject to the sports facility, to the site selection process of 03.140. May I have a second, please?
Second.
Has been seconded by Mr. Haxby. I will speak to this motion. It is my intention to vote against the motion, and here are my reasons for it. Of course, the appellants, plural, contend that it is subject to the site selection process of subsection 140, and particularly Mr. Slivka makes a point of that. In my view, a reading of the section shows quite clearly that either it does not apply at all to sports facilities because that section identifies the principal uses that are subject to the site selection process, and what we are dealing with here is an accessory use. Alternatively, the proceeding is exempt from the requirements of 140 because 140B2B exempts any facility site selection review that has been reviewed by the Commission or approved by the Assembly before January 1 of 2014. And 140B2A1 exempts any site designated for the subject use on a municipal plan adopted by the Assembly. When we look at the facts, we find that on February 13, 2001, the Assembly approved the zoning change of the subject property contingent on the Planning and Zoning Commission approving the site plan. And in fact, the Planning and Zoning Commission approved the site plan on September 24, 2001, which included, quote, sports fields, which included a practice football field and tracks. So, for those reasons, I believe that the site review does not require a new hearing. De novo is specified otherwise by point 140. And either that section doesn't apply at all for the reasons stated, or the site plan review for this field is exempt. I do not find any merit in the appellant's view that 140, that this is subject to the new site plan review because 140 specifies or applies to any sports facility. If we look at that in section 140B, little e, the appellant says that it applies to any sports, entertainment, or civic center designed for more than 1,500 spectators, and in view of the fact that there are to be 1,600 spectators, it's clearly covered. Well, my reading of that section is that any, quote, sports, entertainment, or civic center, unquote, applies to a standalone facility and not to an accessory use. And as this is an accessory use, that 1,500 spectator requirement clearly has no application. So for all of these reasons, I intend to vote no on the motion, which is that the proposed sports facility is subject to the site selection process of AMC 2103-140. Mr. Haxby.
Yeah, I would vote no as well. Page 3-15, I think it's code section 21.05.04. Oops, hold on. 21.03.140B2. There are several areas in there, any exemptions. Specifically, any site selection reviewed by the commission or approved by the assembly before January 1, 2014. And further, under AMC 21.05.040E, where it's an accessory use. So for those reasons, I would vote no.
Mr. Stewart.
Okay. I also keyed on 210504. I'm sorry, 2105.040E. In that high school is an approved educational facility. It includes recreational and sport facilities as accessory uses. And I also looked at the purpose for 2103.140. And it's basically it's a selection of a site before a public facility may be authorized, or publicly owned land is designated for certain public facilities. And that envisions, this is a new, very large facility. It's a very, like you said, a very large facility that appears to be a standalone facility. And if it's a major facility, then it would also require assembly approval. Assembly approval has already been given for this site selection. Could I have the motion restated again?
I I
may have
will
written it down
restate
wrong.
the motion. Is the proposed sports facility subject to the site selection process of AMC 2103-40?
And you made the motion.
I made the motion and Mr. Haxby seconded.
Okay.
You said no, but you just restated this, you didn't restate your motion.
I certainly did, I thought. The sports I'm sorry, the sports, you stand corrected. The motion is, the sports facility is not exempt from the requirements of 2103-140. That was the motion.
Is not exempt.
It's not exempt.
Okay, so I'd like to restate my
Wait a minute.
That,
You just,
It's not exempt.
you said it's not exempt.
It's not exempt.
that would make it.
And you said you will vote against the motion. And-
It is, okay, it is exempt. So voting no says it is exempt.
Correct.
Okay, so I was moving, vote no.
Mr. Stewart, is that still confusion over this?
No, that
Nope.
helps me clarify.
Oh,
what was
I'm
going
so
on.
glad.
No, I intend to vote no for this because the section does not apply.
Okay. I have no further discussion regarding this matter. Anything, Ms. Kitchen, that you wish to bring up? Anything at all?
Nope.
No? All right. Madam Clerk?
Baron Gutchett,
Nope.
Robert Stewart,
No,
John Haxby,
No,
The motion fails by a vote of 0 to 3. All right, we then come to issue number 2. Does substantial evidence support the factual finding of the Planning and Zoning Commission that the South Anchorage High School property complies with the special limitations concerning the vegetative buffer requirement? And if not, does 2113-010C apply? And in order to raise this issue, I will entertain a motion that substantial evidence supports the factual finding that the South Anchorage High School property complies with a special limitation concerning the vegetative buffer requirement.
second.
It's been moved and seconded by Mr. Haxby. I will support the motion because substantial evidence does in fact support the factual finding that the property complies with a special limitation. Ms. Ferguson, the senior planner, testified that code enforcement found the buffer to be compliant, and I read in the transcript that Commissioner Spring found the buffer to be, quote, very substantial. There is, to my thinking, that is persuasive that there is no code violation, even though I acknowledge that there was some testimony that there was a violation. But in reading the record as a whole, I come to the conclusion that there is no such violation, and I'm therefore in favor of the motion. Mr. Haxby?
I as well am in favor of the motion. I read through the transcript, specifically there were planning department notes and comments in the record, I believe on page 11. Also on page 24, it's noted with respect to the landscaping, and also on page 40 of the Star Tech report on the record on appeal. There was information in there, so I will vote for the motion as well. I believe it meets the requirements.
Okay. Mr. Stewart?
okay, I agree with what you said on the record at 43. It also noted that ASD planted 135 evergreen trees in the last 3 years. But I also note that there are some people that are saying there are some vegetative areas that probably aren't up to 75%, because you can see some of the photos that were taken. But I look at that and I think, well, is it 75% for the entire barrier and looking at all of the homes? Because clearly, there's a lot of that barrier is in fact 100% the way it looks, at least in the summertime photos. The wintertime photos that may be a little different. But I don't see there's as stated in the transcript at page 174, there's no evidence of law enforcement finding that the buffer is out of compliance. And if you look at everything in perspective, it does look like there may be some maintenance issues, but that is not what we're looking at here today. And I also note that under AMC 2113-060, the private enforcement actions are available. And there's no evidence that they were ever utilized by any of the area residents. So I intend to support this motion.
I have simply one additional comment, and that is the reason this issue is important to the appellants, of course, is that under new Title 21, and we are dealing, by the way, we have not stated this for the record, and I'm doing that now, we are dealing with a new Title 21, not with the old one. Under new Title 21, AMC 2113-010C, any entitlement to an applicant is prohibited when a structure or land use fails to conform either to Title 21 or to regulations promulgated under Title 21, or to conditions of other entitlements that apply to the use of structure. And if that section, if the Planning and Zoning Commission had found, or we would find that there is such a violation, then 2113-010C would derail the entire site plan amendment process. And that's why this issue is important to the applicants, of course, or to the appellants. And I will state specifically that there is, in my reading, and I'm simply repeating myself, there is no substantial evidence to support that finding that there is a violation, and thus 2113-010C does not apply. And it is for that reason that I intend to vote for the motion. Has that raised any further thoughts in your minds? No? Madam Clerk?
None?
Baron Gutschag,
Yes?
Robert Stewart,
Yes.
John Haxby,
Yes.
And the motion passes by a vote of 3-0. We then come to issue number 3, and that concerns the asserted behavior of 2 MOA employees that, in the views of the appellants, prejudiced the Planning and Zoning Commission's review of the school district application for site plan amendment. And by way of raising this issue, I will entertain a motion that the behavior of 2 MOA employees has prejudiced the Commission's review of the school district's application for site plan amendment.
I'll second.
Seconded, and Mr. Stewart? I will entertain a motion, so you are making this motion, correct?
Sure.
Is it?
Sure he is.
All right, and.
And I'll second.
Wait a minute.
Bob will make it, I'll second it.
Okay, so the record should reflect that Mr. Stewart made the motion that I suggested be made, and Mr. Haxby seconded it.
Or do you want to reverse it, Bob, and I'll speak first?
No, we are
No.
now, the chair has ruled, so that's what it will be. Mr. Stewart.
I got it, Bob.
Helen's, I think, incorrectly stated that one employee, I'm not sure I pronounced this right, Chauncey, was a member of the planning department when she drafted the 2011 application for the site plan amendment. And in fact, in her brief, in Chauncey's brief, she said she was a signatory to that because she was part of the Booster Club for Salt High. And the MOA also had that in their brief. So that clarifies that, she also indicated that she was never an employee of the community planning and development. It was public works employee. And just because you're because you're part of the municipality doesn't preclude you from operating in other venues as a community volunteer like she did here as the high school booster club. In my mind, after looking through everything and looking at the code, the senior planner, Sharon Ferguson, I think what she was doing was working through with the applicant through the administrative process, and that process is laid out in detail in the code. And everything that was described here, even though there may be some discussion as to what was actually said or not said, I think she was complying with her duties under the code, and nothing that I can see prejudiced the process.
Okay. And so you intend to vote against the motion?
I intend to vote against the motion.
Mr. Hagsby?
I intend to vote against the motion as well. There was nothing that I could see throughout the record that indicated that she turned the decision one way or the other. Specifically, if you look back, she did not do any of the drafting for the, as I see, she had no involvement in drafting of the staff for the community development department. So, while she may have participated in the process, I don't see that as an issue here that raises to the level of something that should be questioned. Secondarily, as I remember, the site really didn't have to go through, it was exempt anyway, it was previously approved. I don't think no matter what, it would have impacted the decision one way or the other. The decision that came out with, in my opinion, was appropriate, irrespective of what she did, but I didn't see anything that would say that she prejudiced. Yeah.
Okay, my comments are as follows. I agree that Ms. Schenke, if that's how you pronounce her name, really had no influence whatsoever because she worked for Public Works and not for the Planning Department. And city employees, unless they have a direct influence, are still entitled to exercise their rights, and which in the case of Ms. Schenke was to draft and submit the original plan as part of the Booster Club. Regarding Ms. Ferguson, I think, Mr. Hagsby, you misspoke. Sharon Ferguson was in fact the senior planner who presented the case to P&Z, and so she drafted the planning department's position on the issue. But as the senior planner and as the planning department is required to make recommendations to the Planning and Zoning Commission, it was properly within her job description and within the obligation of what she is to do to recommend or for or against approval. And in this case, the department voted for approval of the site plan review, and there's absolutely no evidence in the record that I could find that would indicate that she improperly, for any improper motive, recommended approval, and it is therefore that I also intend to vote against the motion. Any further discussion? Seeing none, Madam Clerk?
Aaron Guccio,
No.
Robert Stewart,
No.
John Haxby.
No?
And the motion fails by a vote of 0 to 3. We then come to issue number 4. And that is, does substantial evidence support the Commission's finding that the school district's site plan amendment complies with all applicable development and design standards of Title 21? And by way of raising this issue, I will state the motion in the positive, as that has led to complications before. And my motion is substantial evidence supports the Commission's finding, and the Commission meaning the Planning and Zoning Commission's finding, that the school district's site plan amendment complies with all applicable development and design standards of Title 21. May I have a second, please?
Second.
Seconded by Mr. Stewart, thank you. I will speak to my motion. 2103-180F sets forth the criteria that have to be followed for the site plan review. And I'm turning to that right now. And we see that small f, large F, capital F, has approval criteria, specifically 4 of them. And that is what the Planning and Zoning Commission had to find in order to approve the site plan review that the Anchorage School District was seeking. Now, when we come to the decision, into the resolution that's 2015-001, there is no specific sentence that says all criteria of 2103-180F have been met. There is no such one sentence. But in reading paragraph A1 and A2 and A3 and A4 together, it is clear to me that the Commission found that all criteria were met. Paragraph 1 discusses specifically the lighting and the lighting issue, fencing, limiting hours of operation, building home bleacher standards into the slope, treating the bleacher treads, testing noise levels and attempting to mitigate for those noise levels. In other words, they looked at the main considerations here that the appellants have raised, and one of them is the site is traffic, and the other one is noise. Those were the main points on appeal. And the school board, the Planning and Zoning Commission addressed all of these issues very carefully and found that they were met. And not only did they find that in findings A1 through A4, they also imposed specific limitations. Those are listed as B1 through 7. So it is clear to me that the Commission implicitly found that all 4 criteria of 2103-180F were met, and it is for that reason that I intend to vote for the motion. Mr. Stewart?
I agree that it's a implicit decision. It's not specifically stated, but it's implied with everything that they have looked at. If you look at the substantial evidence in the record at 44 and page 370 through 374, you've got extensive analysis on traffic and parking analysis. There's also indication that there was going to be minimum delays and there was plenty of adequate parking. On the transcript at 180, the commissioners said that the facility would not cause big impact on the traffic. At the record at 45, you got, they were going to lower the light fixtures, smaller PA speakers, sound absorption features into the bleachers, and they put the home team bleachers closer to the parking lot, which means they would alleviate parking in the residential area, because that would keep the main body of students closer to their parking in the field. At record at 461 through 462, they did impose additional conditions, and as Baron stated, those conditions are set forth in the findings. And then at the transcript at 16, 17, and 17, there's discussion about the 8-foot buffer fence that is also going to approach a lot of the, or deal with a lot of the problems here. So I am going to be supporting this motion.
Thank you, Mr. Stewart. Mr. Hagsby?
This is a time for discussion, right?
It is. Discussion of the motion, that is.
The question that I have, and I intend to support the motion as well, but the question that I have is that, as stated, does it comply with all of the standards and all of the development design standards under Title 21? And the comment that comes up, and the question that I truly have, is that if you say that it does, and if the commission says that it does, and somebody can point to one small little thing where it says it doesn't apply here, does that send it back to the courts? I can understand where, and from my reading of it, they've gone through huge mitigation standards, they've gone above and beyond to the maximum extent feasible, as required under what, section AMC 21.03.180F. They've mitigated or offset those impacts to the maximum extent feasible. It seems absolutely clear, even when you look under Stantec's report, page 45, and then on also on page 42 with respect to lighting, the scoreboard, and the other things they put in there. But when you make a blanket statement that it complies with all of the standards of Title 21, can that blanket comment be made? That's really a question. And do you understand where I'm coming from?
In a way, I can understand that. Since you're asking me, let me address that.
Yeah.
I think it is one of the criteria. Just because you say it doesn't comply with one little provision does not mean that the whole thing has to fail. Because you need to take all 4 criteria listed in 180F, you need to look at them together. For example, we know that there could be noise issue. We know that, and the school district has admitted that.
Right?
That would be a violation of a particular standard, okay? But the way this has been addressed by the Planning and Zoning Commission is by responding to criteria number 3. The site plan addresses any significant adverse impacts that can reasonably be anticipated to result from the use by mitigating or offsetting those impacts to the maximum extent feasible. So in other words, it does not require 100% compliance with every single last issue. The question is, has the site plan amendment addressed those violations that can reasonably be expected, and those issues that can reasonably be expected? And does it provide for mitigation? And are those mitigations that have been offered, are they reasonable, and are they the best that can be done under the circumstances? As somebody said here, we are not dealing with a situation where there's a requirement that 100% of any possible violation be eliminated. Can't do that. There will be some impact on the neighborhood. The question is, are the mitigation efforts that have been offered and that have been put into effect by the Planning and Zoning Commission, are those the ones that reasonably provide the greatest protection for the neighborhood? That's the issue.
Does the code allow that?
Well, that's what it says right here in 180F3. The site plan addresses any significant adverse impacts plural, that can reasonably be anticipated to result from the use by mitigating or offsetting those impacts to the maximum extent feasible.
Okay.
And that's what the board considered. Are the mitigating efforts, are they ones that are the maximum extent feasible under the circumstances?
Okay. Recognize I agree.
Yes.
I agree with the decision, I agree with the motion. I'm gonna vote for the motion. But the question is that what I'm trying to do is make sure that we don't get into a circular thing here with the code itself. That's going to allow the decision that's been made and then get held up again because they don't meet 100% of the code. So what you're saying is that from your opinion, the code allows you to address significant impacts which could be reasonably anticipated, and that's enough.
Yes. And addresses those considerations to the maximum extent feasible.
Okay.
It doesn't eliminate them.
Okay, so your interpretation would be, this can shut the door.
Yes.
Okay, then we can vote, I'm fine.
Okay.
I'm just looking for an interpretation, because I don't wanna see it go into something where.
Well, we cannot control whether there will be an appeal or not.
No,
You need to
I'm
understand.
not suggesting that, but what is that making sure that code allows you to shut the door. Once you've gone through the door, and that it can't be dragged up for litigation to drag on for 50 years.
Well, now, wait a minute, there can be an appeal.
Of course.
And the Superior Court can conclude that we were totally wrong and that the appellants were correct, either partially or totally.
Sure, and then it goes to the.
And then it
Supreme Court.
either goes back to us, or they send it back to, to P and Z.
Mhm.
And so that is totally possible. And whatever we do here tonight does not do away with that possibility.
Oh, no, of course it doesn't. Okay, I think I've done.
Okay. Mr. Stewart.
No more discussion.
I don't have any other discussion except just for John's sake, is that we're the administrative due process, and then there's a judicial process after this.
Of course.
And the judicial process can go on for a long time, like Barrett
further, are we then ready to vote?
Well,
Yes.
Madam Clerk?
Baron Kuchel,
Yes.
Robert Stewart,
Yes.
John Haxby,
yes.
And the motion passes by a vote of 3-0. All right, we then come to the final issue, and that is, does substantial evidence support the Planning and Zoning Commission's finding that the Anchorage School District Site Plan Amendment addresses significant adverse impacts by mitigating or offsetting those impacts to the maximum extent feasible? And this, to a certain extent, addresses what Mr. Haxby was raising, I believe. So, in order to get this issue on the table, I will move that substantial evidence supports the Planning and Zoning Commission's finding that the Anchorage School District Site Plan Amendment addresses significant adverse impacts by mitigating or offsetting those impacts to the maximum extent feasible. May I have a second, please?
Second.
Has been seconded by Mr. Stewart. I will speak to the motion. I intend to vote in favor of it. AMC 2103-180F3 requires such a finding. It does not require a finding that there is no impact. Absolutely not. Everybody acknowledges in this case, and the record is replete with discussion that there will be some impact. What really needs to be addressed, and what, in my view, the decision by the Planning and Zoning Commission does is it addresses foreseeable significant adverse impacts. And by the resolution, the Planning and Zoning Commission imposed 6 conditions to reduce noise impact. There was justification for not requiring all noise impact measures. Remember, there was a lot of discussion. Apparently the noise consultant had suggested that was it the lighting or the bleachers or something be turned in one direction, and the Planning and Zoning Commission did not accept that and said there are good reasons for not requiring this. And that is evidence that, to my way of thinking, that the Planning and Zoning Commission was not required to slavishly follow all the recommendations of the experts, the various experts that they had been hired, but that they had some leeway in assessing those suggestions and perhaps voting against them when they thought it was appropriate, and that's what they did. So it is for that reason that I intend to vote for the motion. Again, the criteria of 180F 1 through 4 do not impose a zero adverse requirement. It imposes an obligation to provide the maximum remedies feasible under the circumstances. And in reviewing the decision as a whole and reviewing the transcript and the entire presentation, I must say that I'm convinced that the Planning and Zoning Commission adequately addressed the issue. And it is for that reason that I intend to vote for the motion. Mr. Stewart, did you second the motion?
Yes.
Okay. Would you speak to the motion, please?
I intend to support this motion, and the incident you were talking about was the movement of the bleachers. One expert recommended the hometown bleachers be moved closer to the homes.
Yes.
And of course, the reason that the Planning and Zoning Commission did not take that on and do that is that there would have been a greater impact on the parking in the residential area. There'd be more of an incentive for everybody to park in the residential area because it would be closer to their getting out of the bleachers. They put the bleachers closer to the parking for the school, and that alleviated the parking in the residential area. That would be a significant problem. So there's a trade-off that they did there, and one was more feasible than the other, so they decided to leave it right there. So that's an example of them looking at and trying to offset what significant adverse impacts that they were going to see, not just in one area, but in other areas. So they had a balancing act that they had to perform. I believe what they did was correct, and there's a lot of evidence in the record that they have done significant analysis and significant changes in the plan itself and in the construction as to how things are going to be finished and what that impact should do to lessen impact by the light, lessen impact by noise, traffic, and all of those, the key significant factors in this case.
Mr. Haxby, any further discussion?
I'm going to vote for the motion as well. I believe that the mitigation standards or the mitigation measures which were proposed and the mitigation standards that were approved, and throughout the whole record, it's fairly consistent that everybody was concerned, everybody addressed them, everybody was trying to do the best job that they could to help the homeowners out, rightfully so. And yet, if what was actually constructed was not in accordance with what was agreed to, that's a code enforcement issue. And certainly the homeowners, the other people would have the right to get code enforcement involved and say, look, this is not built to standard, this needs to be redone, or that whatever was agreed to by the school district needs to be done. I mean, what's good for the goose is good for the gander. We've seen this in other cases where public is treated different from the private sector, Eagle River. So, I mean, we've seen this stuff before. If they agreed to something, by God, they should do it. They should be held to the same standard as everybody else. But I think that the record is fairly replete with items where, most of the issues, if not all of the substantial issues, were brought up, they were discussed, well thought out, and stated clearly that certainly the planning zone section. So I'll vote for it as well.
Okay. I have one final comment. My heart goes out to the appellants in this case. I am one of those persons who is very sensitive to noise, to traffic issues, to light issues, close to my residence. I can understand that people who are living in the area are unhappy about what the Planning and Zoning Commission is allowing, and if we vote for the motion, what we are really confirming. And that is that there can be changes made to the previously approved site plan that will have some effect on the neighborhood. There is no question about it. But what needs to be remembered is that the original site plan was approved in 2001, a long time ago. And many of the residents who are living there purchased the property afterwards. And so they purchased it with the knowledge that there was a school there, and an accessory of use of the school property is a sports field. And that within the parameters of the existing Title 21, those accessory uses could be expanded, contracted, changed, whatever, and that it would have some impact on the residents living nearby. And when you look at the Planning and Zoning Commission decision here, there is an acknowledgement that there is an impact on the neighborhood. But there's also an acknowledgement that the school district, in proposing to make changes, and the P&Z in further tightening down restrictions by way of conditions that they have imposed, have made significant changes to what, if left uncontrolled, would probably be an unreasonable use of the property by the school district. So, while there is an acknowledgement that there will be an impact, the decision acknowledges that the school district has done the best it can. And so that is what the neighborhood will have to live with. It is an established school, and we are not dealing with establishing a sports center up there. We are dealing with a modification of an existing site plan. And so it is for that reason that I intend to vote for the motion. Any further discussion?
I just have,
Mr. Stewart?
I just have one comment.
Yes.
This is an observation, looking at the photographs and looking at the way the code addresses the buffer zone. It seems to me like some of the trees are doing well and the buffers that were planted are doing very well. Some are not in a couple of different areas. Now, that raises the question in my mind, is it maintenance or is it just complying with the code? The code requires replantings if there's a dig out, or if there's a die out, if there's damages due to weather, or somebody disturbs or removes some. But I see nothing in the code that addresses the actual maintenance, where all of the trees then should have the same opportunity to flourish. And it looks to me like some of those, there are a couple areas where the trees did not flourish for some reason, and it may need to be maintenance.
Well, Mr. Hagsby?
That could even be soil conditions for the type of trees that are there. Who knows?
Well, my response to your question would be that if certain neighbors find that there's perhaps a violation of the condition, to maintain the buffer zone, that they need to go to court enforcement.
Sure.
And say, look, there's a violation of the buffer zone requirement here. Make him do it. And if the code enforcement people agree, then the school district will be made to replace the trees, replant, whatever. So I think there is a mechanism in code to address that. So it is not, and we all know that trees flourish and die and,
Mhm.
So, but I think there is a mechanism here for addressing that.
Okay, so
So-
the other thing I wanted to point out is, I think the 8-foot buffer fence is going to make a significant difference, especially in that back egress area where the trail goes
Okay.
down.
So you would agree with the commissioners who talked about that?
Yes.
Okay.
I have one from.
Mr. Hagsby.
Comment, and I agree with, I live right by the train tracks, so I understand what noise is all about. And you can learn to sleep with the trains rolling by. But the school district did go to some pretty extreme lengths by limiting the number of events per year. And I think they limited them to 10, if my memory serves me correctly. Which, in the scheme of things, I'm not sure that it was a condition of the actual approval. They said something to the effect on page 462, that obtain noise permits is needed to place restrictions on the number, duration, and time of day for a major event. So I'm not sure that they actually made it a condition. However, the school district offered it up, and that, it's possible that the commission just said, well, we're not gonna go with that, that we are or we aren't. But the mitigation measures they offered, I think, were suitable. They did that to the maximum extent feasible to help the homeowners out.
If you will look, Mr. Hagsby, at condition number 5, you will find that what the condition imposed was that events
10.
using the lights and/or sound system are limited to 10 events per year.
Got it,
Now,
okay.
in other words, they could have other events,
Right.
but only 10 events at which the light and the sound system are activated.
Got it.
Okay, so I think that's what you were
Yeah,
referring
yes,
to.
yes, yes, yes.
So there's no absolute limitation on the number of football games that can be out here in this facility. It's just that the
Lights
items that
and
are bothersome to the neighborhood have to be limited. that is light and sound.
Okay.
Okay? Any further discussion?
Yep.
No.
Madam Clerk?
Mary Gucci,
Yes?
Robert Stewart, John Hexby,
Yes.
And the motion passes by a vote of 3-0. All right, having thus attended to all issues that were raised by the appeal, it appears to the chair that the appeal has been denied. And by way of bringing this issue, this entire case to closure, I will entertain a motion that the appeal is denied.
I'll make a motion that the appeal is denied.
Okay, it's been-
Second.
It's been moved and seconded that as a result of our discussion and voting on previous issues, the appeal has been denied. Mr. Hagsby?
I think as you look at the Planning and Zoning Commission decision, the mitigation measures, I think that they did a good job, that the school district did a good job. And unfortunately, there are some instances where it may not need the approval of local homeowners. But, I just believe that, denying the appeal is the correct thing to do.
Okay. Mr. Stewart?
This decision is going to impact those people that are having some impact from this particular plan or site amendment. And that's a tough thing for somebody that's living right there and has to work through that. But based on what I've seen here, it doesn't look like it's going to be a significant adverse impact. There will be some impact. I think they can deal with it. But the biggest thing is, I think the community has to get together and figure out a way to move forward from this so they can all work in the same direction together as a community.
Okay. I have no further comment regarding the motion. Are we ready to vote? Madam Clerk?
Mary Gucci,
Yes?
Robert Stewart,
Yes.
John Hexby.
Yes?
Okay, that concludes our consideration of Appeal 2015-1. What remains is that we need to formalize what we have done tonight, and as is customary, our council will prepare findings, conclusions, and a decision for our approval in conformance with what we have decided tonight. And the question is going to be, when can you do this? By what time? By what date? Not time.
Do you want to organize this so it's the same meeting as the previous issue that you just discussed? Would that be best
Well,
if you guys could?
That would be the most feasible.
Which is
That would
fine
be
with me.
next Wednesday.
That's,
Fine with me.
At 4 o'clock.
Sure.
that's
Fine with me.
July 15th.
Yes.
July 15th.
So
I
would
think
you-
if that seems like it might be the,
That would be the most efficient from our
Yes.
point of view. The question is whether you can have the decision by at least the day before, Tuesday.
yes,
You can?
yes,
Okay, and you can email that to us?
yes.
Okay, so it is then that we will consider this matter one final time next Wednesday, July 15, at the meeting that is presently scheduled for 4 o'clock that day.
So will this one take place at the same time, or will it take place?
Well,
later?
5 minutes later or half an hour later, but it will occur at the meeting that is presently scheduled for 4 o'clock on that date.
All right.
Okay? So then, we need to address a couple more items here, just to cross the Ts and dot the Is. Are there any reports that we need to consider, Madam Clerk?
No?
Courtney,
Nope,
anything you have?
None from me.
Okay. Member comments, any comments? Yes, Mr. Haxby.
I'd like to request our legal counsel, when she's going through these, and she puts the code references in there, but she also slip in the code book page numbers. It just, because it'll be like, what is it? AMC 21.03.140B2, it may come under, it may be under the specific place that she's looking at, may not be under that, the first page of it, it may be 3 or 4 pages back.
Well,
It just helps me for reference.
well, I hate to disappoint you. The difficulty with that is that the particular version that we have may be changed next week, so any page reference would be out the window. So that's why code sections have numbers rather than referring to
Baron,
pages.
Baron, now you're gonna give me trouble, there we go. Okay,
I'm
then-
sorry to
then-
say.
Then could you get me the searchable link?
So what she will, however,
can
be
do that.
able to do is send you a specific email that says, John, you will find code section so-and-so on current version page so-and-so. Can you do that?
I will
I do
need-
not want that incorporated into the
I will need a
finding.
copy of, I don't have a copy of the
See?
same book that you guys do, but if the
Just what
minister.
I'm
I'll
telling
give you
you.
one after the meeting.
Lisa will give me one, and then I can put the current page number, and I'll also send you
The searchable link.
the link to the online version where you can
And
search
which
it.
would be best for me.
Okay,
Okay.
I can
Could
do
you
that
send
for
all of us the
you.
link?
I will send all of you the link.
Yeah.
Mhm.
You want a link to all this?
Yeah,
It's,
Okay,
because you can
good
search
luck.
it there by, you can search it by.
Okay.
by
it's
code.
easy.
Yeah.
Okay.
The old ones.
All right. Yes.
Is
Lisa.
board council gonna depend on the minutes, for writing the decision, as has been the case in the past?
I think I will be able to do it without the minutes.
Okay.
Terrific.
Okay.
Because I take it you were going to say you're not going to have things ready by next Tuesday.
No, I was gonna say I will make it my priority
Oh,
if
no,
so.
no.
Okay.
We're not. We
Lessen
know
your
that you
workload.
have plenty to do, Lisa, so not to worry. Okay, next item, audience participation, and this is a public hearing, so the audience is allowed to make comments. I should caution, however, that audience participation may not concern adjudicatory matters before the Board of Adjustment, and that in this particular case concerns BOA Appeal 2015-1, the South High School issue that we just discussed, nor can it address the motion for reconsideration of Appeal 2014-5. So, subject to those cautionary statements, is there anybody in the audience who wishes to address us and talk specifically? You all look so excited to be here tonight. So, Mr. Slivka.
I would just, thank you for your time and consideration.
Thank you. Anything further? There being nothing further, the meeting is adjourned.